I'll try to speak up. May it please the court, my name is Margaret Kosanne, and with me at council's table is Vincent Citro, and we represent the respondent below, Mr. Patrick Carroll. And we're here on a very, yes, please, 5 minutes. Thank you. We're here on a very discreet but important issue, and that is the proper application of Florida's domestic violence injunction statute, which is section 741.30, and particularly subsection 5C. And that's what applies once a court enters an ex parte temporary injunction.
You didn't appeal the first temporary injunction.
That's correct, but
Okay, so what happened then was she filed a petition, which the court found was not legally sufficient, denied it. She then filed an amended petition on 5/9. The court held a hearing on 5/15 or 5/22, which is within 15 days, timely. At that hearing, what's interesting in your brief is you don't cite any of the transcripts at all. So I want to point to that because what Judge Costello said was we have a service issue here.
correct.
And counsel said for the petitioner, he's got a case in front of Judge Green. He didn't show up for that, so he got a good bodily attachment. So this whole problem, the whole pervading problem in this case is you couldn't serve Mr. Carroll. So if you look at 5C, the court may grant a continuance of the hearing before or during the hearing for good cause shown by any party which shall include a continuance to obtain service of process. So you would agree. It's a reasonable conclusion that Judge Costello extended that particular temporary injunction because of failure to obtain service, right?
Well, what happens on,
No,
if I can go back and explain the procedure,
it's a simple question.
the temporary injunction came after the hearing of
I
522.
understand, but she said it beyond 15 days.
She said it beyond 15 days.
For what reason?
Well,
Failure to obtain service.
failure
correct.
to obtain service,
And
correct?
then so the statute says she can do that.
The statute says she must set it within 15 days once the
Which
temporary,
she did.
at that point, Your Honor, no, the 522 hearing, no temporary injunction had yet been entered
It
So-
was entered on May 22nd.
after the hearing.
Right. And it was extended because it could serve your client. And the statute says the court can do that.
Well, if I can take you through the
I
procedure.
know the procedure. I read this
Okay.
thing back and forth, so I don't need, you just tell me. What's the error?
The error is that the court set the permanent injunction hearing beyond the 15 days
Because of what legal reason?
because of a lack of service.
Okay, doesn't the statute say that?
Not once the temporary injunction is entered. Once the the first temporary injunction came out on May 22nd.
I understand.
And at that
it's
point,
extended to June 26th. And it was extended for lack of service, and the statute says that when it's extended, it shall remain in full force and effect. So it means it was in effect till June 26th.
It wasn't extended at that point because it hadn't yet been entered
It was entered May 22nd.
after the hearing. The hearing on May 9th, I believe it was, the court entered an order setting hearing for May 22nd,
Correct.
but no temporary injunction had yet been entered, Your Honor.
I understand.
And that was
The
perfectly
petitioner
correct.
Showed up and her counsel showed up and said, we can't serve him. He has a hearing with Judge Green. Let's set it then. And you don't cite the transcript at all. Why not?
Well, we included it in our appendix, Your Honor.
Why didn't you cite it in the brief? You don't at all. Judge Costello asked, is there a service issue? Yes, there is, Judge. And here's why. Let's do it for this. And it appears that the statute allows her to do that, correct?
The statute allows her to do that after the temporary injunction is entered.
It
And
doesn't say that. It says it can be continued before or during a hearing.
correct. But the initial permanent injunction hearing was set on May 22nd, but no temporary injunction had preceded that.
That doesn't matter.
Once the temporary injunction was entered on May 22nd, then the hearing had to be set within 15 days because no, it has to be set within 15 days, Your Honor. And then during that hearing, the court can continue it for good cause shown and then extend the injunction. Well, there's no case directly on point, but the statute is clear, Your Honor.
No.
Sure. It says any ex parte temporary injunction shall be effective for a fixed period not to exceed 15 days. No, it says a full hearing as provided by this section shall be set for a date no later than the date when the temporary injunction ceases to be effective. That didn't happen here. And then it says the court may grant a continuance of the hearing before or during for good cause by any party, which shall include a continuance to obtain service of process. So the once the temporary injunction is entered, the court must set the hearing within the 15 days.
Let's go back to the first sentence. The injunction shall be effective until the hearing set above and in no event for longer than 15 days unless. What does it say now? Extended by a quarter. Judge Costello had a conversation with plaintiff's petitions for counsel and said, "What's the best day to set this so we can ensure that he's served?"
But that was before the temporary injunction was entered, Your Honor.
I just want to jump in real quick. Does a trial court judge in Florida have the authority to enter an injunction generally without this statute? Or can trial court judges only enter injunctions?
Well, the injunction that was sought was a domestic violence injunction pursuant to.
I'm just asking a much more general question.
Sure.
Okay. So is that what makes this type of injunction in the context of this type of case different from Jimmy Rice cases? And Jimmy, what's happening in Jimmy Rice cases?
So in Jimmy Rice cases, the statutory structure is similar because both involve a pre-hearing deprivation of liberty to a
Are they
degree.
similar in what the purpose of the statute is?
No.
So in a Jimmy Rice case, you have somebody who's been convicted of a violent sexual felony, right? And that person has served their full term and then they've been released. And the statute exists to provide a mechanism to have them civilly committed, even though they've fulfilled their debt to society, right?
Correct.
Okay. Do you see any distinctions between what might be happening in that type of statute and what might be happening under Chapter 56?
Only to the degree of the liberty that's at issue, but there is.
Isn't that fairly significant? You know, if it's only to that degree, it's like sort of other than that, and that was the show. I mean, isn't that a huge difference?
I think the language in the two statutes is very similar, and the Florida Supreme Court has said the deadlines are mandatory because there is a pre-hearing deprivation of liberty to a degree. And so the court must follow the limitations of the statute.
But in the Jimmy Rice context, you have a statute that exists to take someone who has fulfilled their debt to society in a term of imprisonment, gotten out, and is the court is going to consider locking them up again. And so the statute, the cases construing that statute, which is just saying this is a big deal, go be careful that if you're going to do this, that you do this according to this process. Here we have the court doing something. I mean, Judge Costello could enter an injunction saying you can't sell your vote on breach of contract. I mean, she's got a commission. She's a judge. She was sitting in county civil. She could enter injunctions on someone, you know, based on breach of contract, for example, that they can't do something, right? She doesn't need a statute in injunction, right?
Well, in this case, there's a domestic violence injunction statute.
Right,
And the injunction was entered under that statute.
I understand. But the point is that she's not doing something and entering an injunction that is a pure statutory creature. Someone who's a judge can enter an injunction without a statute. Where, like, for example, let's look at Jimmy Rice. Without the Jimmy Rice Act, can a judge take someone who has paid their debt to society and lock them up without that statute?
No, Your Honor.
So doesn't that make that Jimmy Rice Act process quite different than what's happening in a domestic violence?
I don't think so, in the sense that it's still an ex parte injunction that does deprive the respondent of some liberties without having his day in court. He is deprived of some liberties.
So in your case, what was your client deprived of here?
Well, he was limited in contacting or being near the petitioner.
I didn't see, in the agreement, had he already agreed to limit his contact with the former wife by agreement?
Yes, there was an ongoing family law matter, and there was an agreed no contact order in that ongoing family law dispute. Yes, and indeed, the first petition that was filed merely referred to a contempt motion based on that no contact order in the ongoing family law case. So the original judge said there's no factual basis here, and that's better dealt with by the family court judge. And then there was a supplemental petition filed where the facts were laid out, essentially the same as what were in the motion. And Judge Costello at that point said there is not enough here to issue a temporary injunction, but I am going to set a permanent injunction hearing. And then at that hearing, the petitioner asked the court to consider something that was on a thumb drive. And the court said, you need to go file it and file a supplemental petition, file it with the clerk, and I'll look at it. And then later that day, based on that evidence that was submitted, presumably, the court then issued the first ex parte temporary injunction.
Which
And that
you did not appeal. You did not appeal that.
that's correct.
You moved to vacate the one that was issued June 26, 2024, extending the hearing out to October 30th, 2020.
That's right. That's because the
So
court,
let's not talk about the one you didn't appeal. So the same reason the June 26 order set a hearing beyond 15 days was why? Your client emailed petitioner's counsel saying, I'm in California working with some stars, sun, whatever, for the whole summer. And he also didn't show up at Judge Green's courtroom, so they issued a writ of bodily attachment. So once again, it was failure to obtain service upon him, and then they finally found him in the LA jail.
Your Honor, how can he appear for something that he doesn't have notice of? If he hasn't been served with it, it's a fundamental due process issue. And
It's the nature of this type of injunction that allows domestic violence victims, be they men or women, to get it ex parte. The legislature has weighed the interest of the parties.
that's
Because
absolutely
as you
right.
can see, your client could have moved for a continuance or an extension too. Any party can do it.
But he hadn't been served at that point, Your Honor.
Right, but
And-
didn't show up for Judge Green's hearing either.
Respectfully, Your Honor, that's not the issue that's before this.
Well,
court.
it really kind of is. You can't serve, they couldn't serve the client. And the statute expressly allows an extension for that reason.
Well, if the hearing is set within the 15 days, and that's the problem, it wasn't here.
You can't set a hearing within 15 days if you can't serve your client.
But the statute mandates it.
So I just want to jump in here. So one of my questions is, how many what it would look like if it had been done the right way.
Okay, if it had been done the right way, on May 22nd, when the judge decided that there was now enough here after looking at the thumb drive to issue the ex parte temporary injunction, then that should have set the hearing within 15 days later, not on June 26th, which was more than 15 days later, because the injunction itself said this injunction shall be effective until the hearing set forth above, and in no event for longer than 15 days unless extended by court order. And so the injunction expired by its own terms.
So your client wouldn't have yet been served. Your client, I think, was served on July the 3rd, right? So if the hearing, Judge Kosanne had, in your view, done it correctly, she would have set a hearing at which your client still wouldn't have been served, and then what should she have done?
Then for good cause, which service of process is one, continued the hearing by order and extended the injunction at that point. But because the injunction had already expired, the court lost her statutory authority at that point.
So she would have said it, should she have said it another 15 days?
No, I don't, the statute doesn't limit it at that point. But the initial hearing must be set within 15 days, and then the continuance must be before the injunction expires.
So
That's the absurd result, man, because you're saying it must be set within 15 days, but if the court is given reliable information from one of the parties that you won't be able to serve the respondent, therefore he will not show up in 15 days, the court is handcuffed?
By the statutory language, Your Honor.
well, I think that's where I was trying to point you to. So in your brief on page 9, you refer to section 741.30 for statutes as governing a court's authority to enter injunctions. Is there a difference between a statute that creates a remedy from nothing, you know, like in essence, creates something that didn't exist before, kind of like the Jimmy Rights Act,
Yes.
and a statute that simply says, here's the process by which this type of proceeding will go? Is there any difference in your mind between those two?
Yes, I think there is.
And what is the difference?
Well, because the prior one limits the court's authority to act, and that's what we have here.
So like the Jimmy Rights Act type statute is a limitation on authority.
Yes.
And the other type of statute is one that is simply saying, and here's the process by which we'll do what the court already has authority to do.
Correct.
But you think that the DV statutes are a type of statute that creates an authority that doesn't exist without statute?
Yes, in the domestic violence injunction realm. Correct.
Okay,
This is a distinct type of injunction. And like I said, it's obtained ex parte on one side's mere allegations. And until the party is served, it has no effect.
You're at 18 minutes, you can use your time as you wish. We'll give you a couple of minutes, we can. You wanna?
yeah,
It's fine, Your Honor. It's correct that the initial injunction was not appealed, but on June 26th, the court entered what was termed an amended injunction.
During the hearing.
Correct.
Okay, so how do you, then respond to me. Court may grant continuance of the hearing before or during the hearing.
But the injunction had already expired. Something can't be extended that has already been extinguished by its own.
Sir, what you arguing today?
I'm having trouble hearing you, sorry. Yes, by the plain language of the statute. Okay. If I can use an analogy, if Tom Brady wanted to play for the Bucks again and come out of retirement, he would be entering into a new contract. He wouldn't be extending that contract because that one's already over. And that's the same thing here. A court can't extend an injunction that has already expired by its own terms. And that limitation is set forth very plainly in the statutory language.
Okay.
So thank you.
Yeah, please, court,
So,
counsel. I'm going to rely on the brief that was filed in this case by the appellee. Unless the court has any questions, I'm going to sit down.
well, counsel's argument that no matter what occurs at a hearing, no matter what the court does in terms of setting exceeds 15 days, that injunction has been entered, does at 15 days.
The court does not lose jurisdiction to enter further orders. It's the point that I made in my brief. Going to Judge Moe's point, there are a lot of reasons to enter an injunction. There are a lot of reasons to overturn an injunction on appeal, especially a temporary injunction. So imagine a non-compete case where a temporary injunction's been entered. It goes up on appeal and the appellate court feels that it was improvidently entered and reverses. Case doesn't die. Case doesn't go away. The court doesn't lose jurisdiction. The key here, and you hit on it, Judge Sleet, is that they didn't appeal the first order. Had they appealed the first order, maybe we'd have something to talk about, but they didn't. And I don't think they would have in any event because I agree with the analysis, Judge Sleet. But the fact that they didn't appeal the first order, any infirmities in that first order, any errors in that first order, including when the hearing was set and so on and so forth, you don't have jurisdiction to entertain it respectfully. And
How could they have appealed the first order in a timely way to administer?
can't answer the question, Your Honor, but all I know is that 9.130 requires that a non-final order of this type be appealed within 30 days where the court loses jurisdiction. There are no ways around that. I understand the practical difficulty that you're bringing up, but the legal analysis is pretty clear. So every injunction that was entered thereafter was entered pursuant to those last two sentences in sub 5 sub C, which Your Honor has cited to several times, which allows for continuances. The notion that he could not be served was brought up early and often. And Judge Costello obviously recognized that and allowed there to be an extension of time as the statute authorizes. And so again, unless there are any further questions, I'll say. Thank you, Your Honor.
I give you 1 minute.
Thank you. As to the court's jurisdiction, we did cite some authority. 9.130 does allow the court to hear this matter because the court continued an injunction by its orders that we maintain had died on the vine, and the court exceeded its statutory authority when it did that. But 9.130 does allow the court to review orders that continue an injunction. And we cite a few cases in our papers, Dietz versus Dietz out of the 1st District being one of them. The court noted there that the order at issue, which continued a temporary injunction, is subject to review under 9.130 A3B and reversed and remanded there. The same thing with the Sanchez versus Alvear case out of the 4th District. The statute does not contemplate relief beyond an ex parte temporary injunction without a full evidentiary hearing, and the court reversed and set aside that injunction. And that's what we're asking the court to do here.
Thank you.
Thank you.